you're on the plaintiff side, you go first. So you outline the story, you tell the story to an audience, a group, the jurors who don't know anything about what the case is about, and you play offense. You bear the burden of proof. You have to prove your case to the jurors, and so there's more of an aggressive posture to being a plaintiff's lawyer. It's just in the nature of that role. Many defense lawyers fall into what I think is a trap of playing defense and just watching to see what the plaintiff's lawyer is going to do and react to the plaintiff's lawyer. When I'm on the defense side, I do not use that approach at all. I play as much offense on the defense side as I do when I'm a plaintiff's lawyer. And anybody who tells you that the defense doesn't have to prove the case because the plaintiff bears a burden of proof is not a very wise defense lawyer. You have to convince those jurors, whatever the jury instructions are, whatever the technical burden of proof is, you have to convince those jurors that your client wears the white hat, that the defendant has been wrongly accused, that there's a side to this story which will convince the jurors to relate to the defendant, to want to vote for the defendant. So I really don't have to change so much the dynamic of my approach, whether I'm on the plaintiff's side or whether I'm on the defense side. If you look at cases, personal injury cases and business cases, of course, it's a very different context. Plaintiffs' personal injury cases or defense personal injury cases have to do with human drama that the ordinary juror is very familiar with. Their life stories. They understand pain and suffering. They understand someone being run over by a car or your typical horrible crisis, even accidents that they haven't suffered. They can relate to the human beings and they can relate to the facts that are before them. That's not a difficult situation for them. But if you have a business case, the real job is to try to keep anybody in the courtroom awake, including the lawyers. Because the typical, you have two corporations, one on each side, some cases you're lucky and maybe you have a movie that's at stake or somebody's infringing a copyright, so you can hope that you can get some interest on that. But if it's a breach of contract and it's really about two wealthy corporations, at the end of the day, nobody's going to be devastated by the outcome. Then there's a real challenge to developing a story that you can keep the jurors motivated and interested in what they're going to ultimately be decided, and not just all go to sleep or all become indifferent so that they really don't care much about who wins or who loses. So that's a very big challenge in a business case. When you're developing the story, it's very important to remember that you have to try the case you have and not the case you wish you had, because you could be inspired by literature or movies, and those are not bad places to look for themes, but you really have to deal with the cards that you've been dealt. I was on the defense side of a case where a lawyer had a personal injury case, and the plaintiff was an elderly man, and he had been injured, but he was a very unpleasant, crotchety guy. And the plaintiff's lawyer made a mistake, a strategic mistake. He tried to turn this man into somebody's grandfather, somebody, your uncle that you loved. And it just didn't work. It was horrible. His wife, the wife of the plaintiff, testified because she had witnessed a product went wrong, and witnessed the injury. And you could tell that she didn't really even like her husband very much. So there was a good defense to the case. But I also think that the plaintiff's lawyer developed the wrong story. He tried to turn someone into someone they weren't in order to win the jurors over. If I had been the plaintiff's lawyer, I would have candidly told the jury, you are not probably going to like my client. He's grouchy, that's who he is, but he didn't deserve to be injured by this product. This product was badly manufactured and he didn't deserve to be injured. But because the plaintiff's lawyer tried to make somebody into something they weren't, I think the jurors distrusted the whole plaintiff's case, and I think that helped me get a defense verdict.